Now we'll discuss question number 3, which asks, enumerate the duties of a bailiff, and those duties are consist six numbers. So there are six duties of a Bailey, and as provided under section 151, 152, 153, 154, 155, 157, 160, 161, 165 of the Indian Contract Act 1872. So the first duty to take care, and that is provided under section 151 and 152. The bailey is responsible to take care of the goods belt. According to section 151, the bailey is bound to take as much care of the goods belt as a man of ordinary prudence would under similar circumstances take care of his own goods of the same quality and value. Thus, a bailey is under duty to take so much of care as a person would take care of his own goods. The bailey, in the absence of any contract, is not responsible for the loss, destruction, or deterioration of the things built, since the standard of diligence required from a bailey is that of the average prudent man. A bailey of goods is not liable for loss of the goods by theft in a shop. The bailey is not bound to take extraordinary care. So, regarding that, the Allahabad High Court held in the leading case Union versus LR Cotton Mills in 1971, where Bailey has taken the same care of the property entrusted to him as a responsible, careful man may be expected to take care of his own goods. He is not responsible. Thus, Bailey is bound to take reasonable care. The law on the point may be summed up as follows. So, if the bailey takes reasonable care of reasonable prudent man, then he is not responsible for loss. And if there is any contract, that the bailey shall be responsible for the destruction or deterioration or loss, only then he will be responsible. And if a person does not take reasonable care in respect of the goods belt, he shall be responsible for the loss to the bailiff. So, this position of railway administration is that of a bailey in respect of goods entrusted to it, as it was decided by the Allahabad High Court in the leading case Union versus R.L. Cotton Mills in 1971. So also in the respect of Rangaraju versus Muthu Krishnan in 1963, the Madras High Court expressed the views that the terms and conditions printed on the reverse of a receipt issued by the owner of the laundry and the loss or damage of the things built is prima facie evidence of negligence, and the burden of disproving negligence lies on the Bailey as it was decided by their lordship in 1963 in this leading case Rangaraju versus Muthu Krishnan by the Madras High Court. So we'll discuss regarding that in absence of this, the onus is on the Bailey to prove that the attention of the bailer was drawn by the Bailey to the alleged special condition before the contract was concluded and the bailer had consented thereto expressly or by necessary implication as a contractual term. It cannot be just assumed that the said printed conditions automatically become a contractual term or part of the contract of bailment. It is to be found on evidence in each case as to whether the alleged printed conditions formed a part of the contract of bailment or not, depending upon the conduct of the parties. If a receipt acknowledging endorsement of articles is issued by the Bailey after contract is already concluded, such a receipt may have to be considered as a mere acknowledgement and not as a contractual document in a case which is governed by section 151 and 152 of the Indian Contract Act. The non-return of article entrusted by the bailer to the Bailey by itself is prima facie proof of negligence of the Bailey. The burden of proof is always on the Bailey to prove that the Bailey took reasonable care of the goods entrusted to him as a man of ordinary prudence who would have exercised it. So, in the leading case, R.S. Debu versus Hindalkar in 1995, the Bombay High Court expressed the printed condition did not form part of the contract and the plaintiff had not assented thereto expressly or by necessary implication. It was never covered by the defendant to the conveyed to the by the defendant to the plaintiff at any time, directly or indirectly. The plaintiffs have no real and effective notice in respect of alleged special conditions. The court cannot accept the defense of immunity based on the printed condition. In every event, the said receipts were merely receipts or acknowledgement and were not in the nature of a contractual document. The contract of bailment between the parties was concluded orally and the suit receipts were issued by the owner of the laundry little later. In this view of the matter, also conditions relied on by the defendant as a ground for exemption cannot constitute a valid defense in respect of claim for compensation for non-return of the articles entrusted by the plaintiff to the defendant as it was held by their lordship of Bombay High Court in the leading case R.S. Devu versus Hindalkar in 1995, and the second duty of the Bailee is that not to deviate from the terms of contract, and it is provided under section 153 of the Indian Contract Act 1872. So, the very provision is that a contract of bailment is voidable at the option of the bailer if the bailee does not act with regard to the goods bailed inconsistent with the conditions of bailment, and in connection to that we will discuss some illustrations such as illustration A lets to B for hire a horse for his own riding. B drives the horse in his carriage. The termination of bailment is at the option of A if the contract is that the goods shall be deposited at one place and they are deposited by the bailee in another place, the bailee will be liable for any loss or damage that may cause due to his such deviation from the terms of the contract, and as it was decided by the Queen's Bench division in the leading case Lilly versus Doubleday, and in another leading case, and that is Edwards versus Newland in 1950, the Allahabad High Court decided that goods were bailed with A who places the goods in the custody of B without the bailer's authority. Damage is caused to the goods while in the custody of the third person. The bailee is liable for a breach of duty. And now we'll go to the third important duty of the bailee is not to use the goods bailed unauthorizedly, and as it is provided under section 154 of the Indian Contract Act. So, If the Bailey makes any use of the goods belt which is not according to the conditions of the bailment, he is liable to make compensation to the bailer for any damage arising to the goods from or during such use of them. And the very illustration relating to that section 153 is that section 154 is that a lends a horse to B for his own riding only. B allows C, a member of his family, to ride the horse. She rides with care, but the horse accidentally falls and is injured. B is liable to make compensation to A for the injury to the horse. And the second illustration relating to section 154 is A hires a horse in Calcutta from B expressly to march to Banaras. A rides with due care, but it marches to Cuttack instead. The horse accidentally falls and is injured. A is liable to make compensation to B for the injury to the horse. If, however, the loss of destruction was due to some inherent defects in the goods themselves, and loss should have occurred in any case, this will not be considered a loss resulting from the unauthorized use of the goods, and the bailiff shall not be responsible for the loss. If the bailiff makes an unauthorized use of the goods, the bailor has the right to terminate the contract of bailment forthwith. So, the next important duty of the bailey is the fourth one, not to mix the goods with his own goods as provided under sections 155 and 157. And in that connection, we will discuss also an important leading case, Lofton versus White. So, the very duty not to mix the goods with his own goods. Sometimes the goods of the bailor and bailey becomes mixed. Such mixing may be with the consent of the bailor, or it may be the result of an accident, mistake, or it may be willful or intentional. If the bailey, with the consent of the bailor, mixes the bailor's and bailey's goods shall be interest in the proportion of their respective shares in the mixture thus produced. And secondly, if the goods are mixed by accident or by the act of God, and if the mixture is composed of similar kind and quality, it belongs to the bailor and the bailey as tenants in common. Any attendant cost of separating them to be borne by the bailey as it was decided in the leading case, Lofton versus White. And also, if the goods are willfully and intentionally mixed without the consent of the bailer, and if they can be separated, the bailee is bound to bear expenses of division. But if they are impossible to be separated, the bailer is entitled to be compensated by the bailee for the loss of good. And now we'll go to the fifth duty of the bailee, and that is return of goods billed on expiration of time or accomplishment of the purpose, and as they are provided under section 160, 161 and 165 of the Indian Contract Act 1872. So, as provided under this section, it is the duty of the bailee to return or deliver, according to the bailor's direction, the goods billed without demand as soon as the time for which they were billed has expired, or the purpose for which they were billed has been accomplished. So, bailee's responsibility when the goods are not duly returned, if by the default of the bailee the goods are not returned, delivered, or tendered at the proper time, he is responsible to the bailor for any loss, destruction, or deterioration of the goods from that time. So, where there are joint bailors, the bailee may deliver the goods according to the direction of one joint owner without the consent of all. This is possible only if there is no contract to the contrary. And the last duty of the bailee is not to set off a title, and in relation to that we'll discuss the provisions of section 117 of Indian Evidence Act. So, not to set off a title by virtue of section 117 of Indian Evidence Act, a bailee is estoppel to set off a title adverse to that of a bailer. But if a bailee delivers the goods billed to a person other than the bailer, he may prove that such person had a right to them as against the bailer. So, these are the six most important duties of a bailee towards the bailer, and all these could be the exact and appropriate answers relating to the question enumerate the duties of a bailee.